And now, here's attorney Kevin Crayon.
So I'm over here at the federal courthouse, United States District Courthouse, where I've just completed a jury trial and now I am waiting on a jury verdict. And you may have seen my video, part 1, about how did we get to the part where we did a jury trial. And now I will talk about what happens when you do go to court. 5 things that you can expect if you are doing a jury trial, particularly if you are doing a jury trial for a discrimination case, an employment discrimination case. Number 1, opening statement. You tell the jury what you expect the evidence to show. Statistics show that a jury will often decide a case or have a strong impression of a case based on the opening statement. And when you're doing an opening statement, you should have a theme, a catchy hook phrase, something that you say 3 times. People remember the rule of 3s. They shut my client down. They shut her down when they told her she couldn't come to work. They shut her down when they refused her a reasonable accommodation. They shut her down when they didn't leave her any alternative but to quit her job because she wasn't accommodated. She was shut down. Boom, boom, boom. 3 times you hit them with that. In your opening statement, you should talk about the story, talk about the facts. It's not supposed to be argumentative. Number 2, witnesses. In federal court, the federal rules of civil procedure apply, and so you have to issue subpoenas to the witnesses. So you need to look at the federal rules of civil procedure on how to do that. And that's how you secure your witnesses. It's telling them where they have to attend, when they have to attend, and then you also have to give them their fee for attending. And so the fee is something that's in the law as to how much per day of attendance. Coordinate with your witnesses and contact your witnesses ahead of time. Discuss the facts. So that way, when you have that witness appear, you already know what they're going to say. Now, if they are a hostile witness, you may not be able to contact them directly, or they may not be cooperative. And so that's where pre-trial procedures come in, like discovery, or maybe they've already given an affidavit. The third aspect of a trial is the questioning of witnesses. So there's cross-examination, and then there's direct examination. This means that if you have a witness that's favorable to you, you're supposed to only ask direct examination questions, meaning you leave the questions open-ended. They have to be non-leading. So for example, what color was the light when you approached the intersection? What was your medical condition? See, that's an open-ended question that allows the witness to tell you what a leading question on cross-examination. Let's say I have a manager up there, and I may say, well, isn't it true that my client had a neck and back injury? See, that's a leading question, and that's allowed on cross-examination. On cross-examination, you want to make sure that you only ask questions that you know the answer to. Because by the time you get to trial, you want to keep witnesses on a short leash if they are hostile witnesses. You want to ask one question at a time, and you want to already know the answer to it. You have to have documentation to support it, because hostile witnesses will be evasive or say, I don't recall, or you need to show me a document. And so then you'll have to be ready to pull up those documents at any given time. So when you're drafting your questions, you really have to be more meticulous on cross-examination preparation. Keep a hostile witness on a shorter leash. You already know the answers. Get the answers that you already know should be given. And if a hostile or adverse witness deviates from the script, you're able to pull up maybe a prior inconsistent statement. Number 4, closing arguments. As a trial strategy, I always recommend you draft your closing statement in advance. I believe it's one of the first things that you should write when you're preparing for the case, so that you can make all of the evidence fit that closing statement. And the closing statement is the end result. It's the argument that you're trying to make. And so it makes sense as a trial strategy to start with your closing statement and draft it up and then make sure that all of the evidence, it fits your narrative. There's a few good tips. Number one, you should reiterate your theme. Like, they shut my client down. They shut down her reasonable accommodation request without any further discussion. They shut her down. So that's just an example of a theme. Give the jury a preview of the law, of what the judge will instruct them on. So you can say something like, the court or the judge is going to instruct you what it means to be a disabled person, Americans with Disabilities Act, or the Rehabilitation Act. You can preview for them certain instructions. That way, when they hear it again from the judge, it hits home. Repetition can be good, and you're allowed to argue. You can say, hey, at the beginning of this trial, I told you that I was going to prove these things, and now we've proven it. So even though you prepare your closing statement in advance, as you're going along in the case, you should have a separate notebook for items that you want to make sure that you include that come up during trial. Because certain things come up in trial that may not have been anticipated, or that may strengthen your case, or the other side may come up with something that you feel might be damaging to your case. So you want to make sure that you have a notebook to make sure that you include those points in your closing statement. I also like to, as a strategy, to include the jury verdict form. You show it to them. Say, hey, this is the verdict form that you will have to fill out. Here is why you should answer in favor of my client. Juries are lay people. They're not lawyers usually. They're not usually trained in the law. It's very helpful to just give them a preview. The repetition is good. And then in your closing statement, make sure you close with your theme again, so it really sticks in the mind. It's a theory called primacy and recency. People will remember the first thing that you said, primacy. They will remember the first thing you say, and they will remember the most recent thing you said, meaning the last thing you said. You want to open with your theme, and you want to close with your theme, and then hit them with the threes. Say it 3 times in a different way. The fifth element of a trial that's very important, make sure that the jury instructions that go back with the jury are favorable. The judge is the one that's going to instruct the jury, but the judge will usually give you an opportunity to submit proposed jury instructions. Now, luckily for you and us lawyers, we don't have to start from scratch. There are already templated jury pattern instructions. They're called pattern jury instructions. So you'll want to look at whatever circuit you're in, the Court of Appeals website that's in your circuit, pull down a draft of the pattern instructions, and then you can make some deviations and alterations if the judge allows. Again, you're just proposing this for the judge to approve. More importantly, you want to look at what the opposing party is trying to propose to the judge, because sometimes they may try to include instructions that are not so favorable to you and not so favorable to your client, or that are misleading, or they may try to pigeonhole your case into a category. The actual jury verdict, the judge will allow you to have some kind of input into the jury verdict form. And this is very important because you don't want the jury to be misled, especially if the other side is trying to include elements in a jury verdict form that are misleading. You'll want to carefully review the jury verdict form, ensure that during a conference with the judge, you raise any objections. Then the judge will give the jury instructions and send the jury back, and the deliberations will begin. Now, we don't know how long that process takes. It could be an hour, it could be days. That part is unpredictable. You should make sure that you remain around the courthouse or remain on call so that you can receive the jury's verdict, and hopefully it would be in your favor. So if you've made it this far to a jury trial by yourself, congratulations, but I highly recommend that you get an attorney by this point in time. So those are 5 tips that I give you regarding a jury trial. This is us. Okay, we'll be there. All right, thank you.